four of us who are able to vote. Is that correct, Brett? I'm going through the participants here to see if anyone else has joined, because we need, is it 5 for a quorum or 6 now that we have a new member?
It remains at 5.
Okay, so it's now 8:32.
We have 5 members in attendance.
I'm trying to see what we could do without a quorum so we could get started. Oh, we have 5, did you say?
Yeah, we do.
Who, 1, 2, 3, 4. Who's on that I don't see? Oh, Lisa's here. Perfect. Okay.
Yes.
So let's get started because we have a packed agenda. All right. And you got the recording going. I see. Thank you. All right. So good morning, everyone. Just figure this out. Okay. Good morning, everyone. I'd like to call the regular meeting of the Board of Examiners for Nursing for July 15th, 2026 to order. I would like to remind all parties that the board meeting, please mute yourself. Please mute yourself. I would like to remind all parties that the board meeting and hearings are formal legal proceedings and that all parties should conduct themselves accordingly. The board meeting is recorded and posted on the board website for future viewing. My name is Mary Dietman, and I am acting chair today for Gina Reiners. I'm an RN member and an APRN. So I'm going to call the board members to see if they're present, and please introduce yourself as being here. Sal Diaz.
Yep, I'm Dr. Salvatore Diaz. I am a RN member and educator.
Thanks, Sal. Lisa Freeman. Lisa, you may be muted.
And I was muted. I was, I'm sorry.
Okay, that's okay.
Lisa Freeman, and I'm a public member.
Thanks, Lisa. Cindy Arpin.
Good morning, Dr. Cindy Arpin. I am an RN member and a nurse educator.
Thank you, Cindy. Camille Payne. Brett, do you see her on? I don't have the participants pulled up
Yes,
right now.
I just let Camille in.
Ah, okay, we'll come back to her. Diane Whitley. Brett, any chance you saw Diane or no?
I have not seen Diane yet.
Okay, Susan John. Did I pronounce your last name correctly, first of all?
It's Jan. I'm Susan Jan, and I'm an LPN member.
Thank you, Susan. Okay, Camille Payne.
Hi, good morning, everyone. Dr. Camille Payne, APRN member.
Thanks, Camille. 1, 2, 3, 4, 5. That's 6 of us already, right? So I'll say Diane again. Diane, are you here? Okay, if she comes on, we will have her introduce herself. Members of the Department of Public Health, would you like to introduce yourselves, please?
I'll go first. Good morning, Dana Dalton, Department of Public Health.
Hi, Dana.
Good morning.
Suzanne Camerata, Department of Public Health.
Hi, Suzanne.
Good morning.
Dina Early, Department of Public Health.
Well, good morning. Let me write you down. Go ahead.
Good morning, Brett Karpuska, Department of Public Health.
Thanks, Brett.
Good morning.
I just admitted Diane.
Oh,
Thank you. Keep going, DPH staff.
oh, good morning, Helen Smith, Department of Public Health.
Hey, Ellen.
Morning. I apologize. My camera is not working at this moment.
No worries.
Good morning, Taylor Notchick with the Department of Public Health.
Taylor. Welcome, Taylor.
Thank you.
How about any attorneys for, oh, keep going, sorry.
Sorry. Good morning. This is Diane Whitley. I'm one of the board members.
Hi, Diane. If you could just state the type of member that you are, welcome.
Yes. Good morning. Practical nurse member.
Okay, thank you. Any other members of the department like to introduce themselves? Any department attorneys and then our board counsel?
Good morning, Liz Bannon, Deputy Legal Director at DPH.
Hi, Liz.
Hi, Mary.
Anyone else? Any DPH attorneys? Or any attorneys on? Okay. All right, so let's move to the agenda. First item on the agenda is minutes from June 17th, 2026. Can I have a motion from a member of the board, please, for the minutes?
Hi, this is Sal. I'll motion to approve the minutes as written.
Second, thank you, Sal. Second.
I second that. This is Diane Whitley.
Thanks, Diane. Okay, we vote on that, or we just all have an affirmation of aye?
This is Liz Bannon. The board can just vote by acclamation. So the latter, Mary, the board can just vote aye, or presumably nay.
Thank you. And I'll also do abstain. All in favor?
Aye.
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 Opposed? Abstain.
This
Abstain.
is Cindy. I'll abstain. I was absent.
Yep. Susan Yan, I'll abstain. I was absent as well.
Thank you. Okay, perfect. Thank you so much. I'd like to make a quick announcement because we have a packed agenda. We are delighted to welcome a new member to the board. Her name is Susan Yan. She is an LPN member. Susan, is there anything you would like to say in terms of an introduction? Tell us a little bit about yourself, or even just say hello.
Hi, well, good morning. My name is Susan Yan, and I'm a new LPN member, and I've been a nurse for over 35 years and have a very diverse background in nursing, and I'm very happy to be here.
Welcome.
And we're welcome. Yeah, we're super
Thank
happy
you.
to have you. Thank you.
Thank you.
Please ask any questions that you have. I apologize if I'm moving quickly today, but as I said, we have a packed agenda. Oh, sorry, Attorney Bannon has her hand up.
Thank you, Mary. I just wanted to quickly say to Susan, welcome. We're very excited to have you on the board. And just very quickly, I think you already did this with respect to the minutes, but because you are a new member, you know, you may abstain from certain votes. A reasonable basis to abstain is if you don't have enough information to have formed, you know, a decision one way or another. So I noticed you did do that with the minutes, and you certainly can do that going forward. You know, as with all board members, there is an expectation that, you know, during these meetings, you have read the documents that Brett has uploaded onto the secure site so that you can make informed votes. But certainly, you know, this is your first meeting. We have a packed agenda. You're going to see a little bit of everything. So I just wanted to let you know that it is appropriate for you to abstain if you determine so yourself.
Thank you.
And welcome. Thank you.
Thank you very much.
Thank you, Attorney Bannon. Next item on the agenda is motions for summary suspension. First item, Pappy Bebo, and please correct me if I am stating any names wrong today. RN petition number 2026-434. Staff Attorney Kataya is the staff attorney on the case. Are you here?
I am here, Madam Chair.
Thank you so much. How about the respondent, Pappy Bebo?
You have the wrong name. My name is Dana White.
Dana, you're later on the agenda. You're number 6.
Oh, it said 8:30 on my email. Okay, what time then do I get on? Sorry.
So Dana, the meeting starts at 8:30 and ends at 12:30. So you are number 6. I'm sorry, I can't give you a definite time. But it kind of depends on how the meeting flows. So
okay.
Okay. You'll be number
All right.
6. We're on 3
Number
right now.
6.
Yeah.
Okay, thank you.
You're welcome. Okay, so not hearing that the respondent is here. How about counsel for the respondent? Is there counsel here?
I have not received any letter of representation on this matter.
Thank you very much, Attorney Kataya. Would you like to say anything before the board takes up this matter?
Yes, I'll give a brief presentation about the allegations in this matter. This is regarding Poppy Bebo. He's a registered nurse. He holds license number 103559. And petition number 2026-434 alleges that on or about February 8th, 2026, while working as a new nursing supervisor in Windsor Locks, Connecticut, he committed certain acts which failed to conform to the accepted standards of the nursing profession, including but not limited to failing to call emergency services for a missing resident and failing to call 911 or call the physician when the resident was found with an altered state. The department believes that respondent's continued practice as a registered nurse presents a clear and immediate danger to the public health and safety and requests the board summarily suspend his license until a full hearing on the merits can be held.
Thank you very much, Attorney Kataya. Board members, may I have a motion on this summary suspension?
This is Cindy. I'll make a motion to move to grant the department's motion for summary suspension for Pappy Bebo RN petition number 2026-434 as the respondent represents a clear and immediate danger to the public health and safety if allowed to continue the practice of nursing. And I would also like to suggest that this goes to a panel hearing as opposed to a hearing officer.
Thank you very much. A second?
This is Sal. I'll second.
Second, Lisa.
Okay, Sal and Lisa, 50-50. How about a discussion? Anybody have a discussion on this, board members?
It's pretty serious allegations, and it has to do with standard of conduct nursing care. So that's why I think a panel of board members would be most appropriate. And Attorney Bannon, I hope that was appropriate to add that into my motion.
Cindy, I think it is appropriate to make that suggestion. Absolutely. Thank you.
Thank you.
Thank you, Cindy. And Attorney Bannon, anyone else have any comments?
This is Lisa. I just totally agree with Cindy. I think this is a very egregious charge and very serious.
Thank you, Lisa. This was actually a very difficult report to read, so I agree. Any further discussion before we take a vote? Okay, Sal Diaz,
Aye.
Lisa Freeman,
Aye.
Susan Yan,
Aye.
Cindy Arpin,
Aye.
Camille Payne,
Aye.
Diane Whitley,
Aye.
Mary Dietman, myself, aye. Moving on to the next matter, Edwin Cartich, RN. Petition number 2025-882. Again, for summary suspension, Attorney Kataya is a staff attorney. Is the respondent here? Is Edwin Cartich here?
I am present.
Okay, and I don't see you on camera. Are you on camera or no?
I am on camera.
Okay, and do you have counsel?
No, I petitioned time for it, but I was denied, so I still don't have counsel.
Okay. So, Attorney Kataya, anything you would like the board to know before we do our vote and
Yes.
discussion?
Yes, Madam Chair, this is petition 2025-882 involving Edwin Cardock, who currently holds Connecticut registered nurse license number 179419. Mr. Cardock was identified as one of the Nightingale nurses that he attended Azure College nursing program. And he was identified as the director by the director of the program as one of the persons who received a transcript and diploma despite having not completed the approved nurse licensure program. The department's position on all of these Nightingale cases has not changed. It is still the position of the department that permitting respondents to continue practice as registered nurses when they have not completed the approved program represents a clear and immediate danger to public health and safety. And we request that you summarily suspend his license until a full hearing can be held.
Attorney Kataya, thank you. Attorney Bannon, do I allow the respondent to say anything at this point, or we just go to vote, or we just go to board discussion?
My recommendation would be to go to a board vote or discussion.
Got it. Board members, do we have a motion on this summary suspension?
This is Cindy. I move to grant the department's motion for summary suspension for Edwin Cardock, RN, petition number 2025-882, as the respondent represents a clear and immediate danger to the public health and safety if allowed to continue the practice of nursing.
Thank you, Cindy. May I have a second, please?
Lisa, second.
Thank you, Lisa. Board discussion, if any.
I did not add in whether I thought it should go to a hearing officer or a panel. Maybe we can discuss that. We've gone to hearing officers, but we're finding that might not be the best decision. So perhaps these cases should go before a panel.
I agree that that should be discussed in light of recent events. So we can, I think, keep the motion as is, have a discussion, and then deny it and change the motion or oppose it. Attorney Bannon, what do you think? You got your hand up.
I was going to address this later, but I was going to say that if the board does grant the motion, we already are working to put together a panel, and Mr. Cardock, I will address this once the board votes in the event I need to address it, but we are already identifying a panel in the event this does go to a hearing.
So in Cindy's motion, she should include panel hearing, so it's clear. Is that correct?
She doesn't need to, but you know, we are hearing the board's comments, so she doesn't need to include that in the motion. It doesn't hurt to, but you certainly don't need to include that in the motion.
Thank you. Any further comments or any comments from board members or any discussion, I should say? Sorry.
This is Sal. I'll just say I do agree with Cindy in light that this needs to go in front of a panel, and hopefully have at least one educator on that panel, if possible.
Thank you, Sal. I am in agreement with Cindy and you, and believe that that is essential moving forward. Are we ready to take a vote, or is there further discussion? Hearing none. Sal Diaz,
Aye.
Lisa Freeman,
Aye.
Susan Yan,
Aye.
Cindy Arpin,
Aye.
Camille Payne,
Aye.
Diane Whitley,
Aye.
and Mary Deepman vote aye. So both motions for summary suspension are granted. Moving along to,
Mary, if I may just quickly, I see that Mr. Cardock was on, so if I can just briefly let him know the next steps.
sure, of course.
Okay, Mr. Cardock, so the board just voted to grant the department's motion to summarily suspend your license. And under the statutes, we will be scheduling a hearing on the underlying statement of charges promptly, which usually means within the next 2 weeks. So please just make sure that the department has your current address and email address, and keep an eye out for a notice of hearing.
Thank you, Attorney Bannon. I'm sorry,
Thank
I
you.
probably should have said that.
No problem.
Okay. All right, we're ready to move forward, I think. Next item on the agenda, number 4, proposed memorandum of decision and supplemental briefs. This is continued from the last 2 meetings. So board members, please realize that you have had to review those meetings, not only the transcripts, but the videos, okay? And so this is on Rochelle George, RNAPRM petition numbers 2025-299, 2025, 298. Attorney Fazina is the staff attorney. Attorney Fazina, are you here? Oh, Elizabeth, go ahead, Attorney Bannon.
I promise I won't usually be so involved, but we received, the hearing office received communications from Attorney Menschel's, I think it's a colleague of his, who indicated that Attorney Menschel has been stuck in traffic. So he is requesting to pass this matter until he can log in, with the hope that he can log in. Otherwise, he's asking to continue it. So my advice to the board would be to pass this, continue on with the agenda items, and then perhaps once we get through 6 or 7, we can check in to see if he's available. Otherwise, my advice would be to continue this to the board's next meeting in August. So in short, my recommendation is to the board to pass this agenda item for now.
I'm fine with that plan. I don't know if we need to take a vote on that, but I'm okay.
I think you can just pass it as the chair.
Okay, so let's skip 4 for now. We'll try and go back to it if the attorney Menschel can get on. So we're going to move on to agenda item number 5 with consent orders, and there are 3. First is on Gregory James Orfatelli, RN petition number 2025-67. Attorney Anthony Nanny is the staff attorney. Are you here, Attorney Nanny?
Attorney Nanny was unavailable this morning, and he asked me to cover both of his consent orders. So I, Julianne Gataya, will be representing the department in presenting these consent orders.
Thank you so much. First of all, respondent Gregory Orfatelli present?
Here, I'm present.
Just trying to see you on the camera. I don't see it, but Sal, I'll get to you in just a second. Thank you, Mr. Orfatelli. Attorney Richard Brown is the respondent's counsel. Attorney Brown, are you present?
Yes, good morning.
Good morning. I'm glad you're not stuck in traffic.
I
Okay.
live 10 minutes away from my office, so it's pretty good.
All right, good. I see that board member Sal Diaz has his hand up. So, Sal?
Yes, I am going to recuse myself from this case.
Okay.
As I know the person. Great.
Okay, so thank you for letting us know. And you can just turn off. Oh, you already did. All right. So, do the attorneys want to make a statement before the board has discussion? We'll start with Attorney Kataya.
Yes, thank you, Madam Chair. This is the matter with Greg James Orfatelli, petition number 2025-67. He currently holds registered nurse license number 141118. Mr. Orpatelli does have a history before the board. He has had prior incidences, most recently in 2019, where he was placed on probation in connection with some substance abuse allegations. He successfully completed that probation. However, there have been new allegations that he abused or used to excess buprenorphine and naloxone, that he may have diverted some of these medications from his workplace, and that this may affect his practice as a registered nurse. He has since these allegations been compliant with recovery track. He has been attending therapy and he has been endorsed as safe to return to practice repeatedly by his therapist. The current proposed consent order would place him on another 4-year probation, during which he would submit to regular random urine screens. He would be required to continue attending therapy and anonymous meetings and have reports submitted by his therapist and by his employer endorsing that he is continuing to remain sober and practicing safely and competently. The department respectfully requests that you approve the consent order as proposed.
Attorney Kataya, thank you very much. Attorney Brown.
Yes, good morning, everyone. I am the attorney for the respondent, and I've been representing him now, I don't know, close to 2 years, year and a half or more. And the reason I bring that up is I do a significant amount of work, and I can tell those that are serious about dealing with their issues and those that perhaps aren't. My client is clearly very serious about the work that is necessary for him to deal with his addiction. You know, he understands that we have an addiction. You really always do. The real question is it acting out? Is it something that is under control? Are you taking it seriously, and are you doing everything possible to make sure that that in fact you will not present a problem should this board see fit to reinstate you? He understands that the conditions necessary will be very tight, very strict, and apparently zero tolerance. Sometimes people say what they're going to do. I'm going to point out to the board what he's done. What he's done is, I believe for the last 18 months, he's in recovery track now. But before that, he was being monitored. And I believe for the last 18 plus months, he's been drug-free. He's come up negative for drugs. He also is continuing with his therapy. He's in a very good spot. And by continuing with the therapy, I mean both individual therapy and group therapy. I requested letters from people that are in a position to know about him. So one is, of course, as was pointed out, his medical doctor, who has been seeing him and has recommended that he does not present a present danger, and that it would be appropriate and suitable for him to be reinstated with conditions. In addition to that, interestingly enough, I have a letter from High Watch. That was a place he did work, and Maureen Didden, who some of you know, had been with Haven for many years, has also indicated that should you see fit to reinstate him, that they have a job for him at High Watch. Why? Because he is a very good nurse, and his issues unfortunately have steered him away a little bit from the trail. But my point being is, Ms. Didden is not someone that I think a candidate could fool or whatever. She has many years history of dealing with people with substance abuse. And when she puts her stamp of approval on it, I would submit that should matter. In addition to that, I presented a letter from an employer. The reason I presented that letter is one of the things that the board, I'm sure, is concerned about is reliability. If we reinstate him, is he going to show up for work? Is he going to be responsible? And while the job he had is totally different from that of being a registered nurse, the point of the letter was that he was a very reliable person in his job, showed up when he was supposed to, and had the satisfaction of his employer. Finally, there's a letter that I'm sure you all read from my client. He wrote the letter. I didn't. I don't write letters from my clients who are seeking reinstatement. I don't think that's ethically correct. So the words are his words, not my words. And it's clear that it's been a painful experience for him, but one in which he's grown and learned. And I believe, I know it's not easy, but I believe that if you give him the opportunity, he will not let you down. Thank you.
Attorney Brown, thank you. Board members, can I have a motion, please, on the consent order for Gregory Orfatelli?
Are we able to discuss something that's part of it first?
I believe the protocol
Or
is
do we
to
have
make
to
a
do the
motion
first?
first
Yeah.
and second it, but
Yeah.
you know, if somebody else knows Robert's rules better than me, Attorney Bannon, what do you think? Discussion or go to motion first and then discussion?
I think that there needs to be a motion to bring the consent order to the table for discussion.
I agree. Thank you. So,
Okay.
can I have a
Sorry, I'll
motion
wait.
on this consent? That's all right, Lisa. No question. You will definitely have, you know, a turn for discussion because I always want to hear what you have to say. Anyone have, can somebody make a motion on, Mr. Orfatelli's consent order?
This is Lisa. I make a motion that we accept the consent order for Mr. Orfatelli, petition number 2025-67.
Thank you, Lisa. Do I have a second?
This is Cindy. I'll second that.
Okay, so now we'll have discussion. Lisa, do you want to
Okay.
start since? Yeah.
Sure. I'm chomping at the bit. I just have one question, and forgive me, but my computer for change is not quite behaving properly. So while I read it, I can't bring up the consent order at this very moment. The problem and concern that I have is that there was mention that he took patient medication for his own use. Attorney Brown brought that up, and I'm just concerned if we're not addressing that because that's an ethical issue and it perhaps caused harm to somebody. We don't know. So I would like to know what my fellow board members think about that. Not addressing it. Should we address it? Should it be added as a feature of the consent order to somehow address that? Because it kind of goes outside of just the substance use disorder.
Lisa, thank you for your comments. Anyone, any other thoughts from board members?
This is Cindy. I'll just say, I agree, Lisa, that that's an issue when there's a potential that a patient did not receive their medication. I don't know if that was the case here. I'm not sure what else what would you suggest we add to a consent order regarding that?
In this particular case, it's kind of, I think, a peripheral issue. I just hesitate not addressing it at all. So possibly just I just lost the word, a reprimand of some sort or a nominal fine, just, you know, so that we can kind of make a point. It's not something that we want to in any way condone or condone by omission.
Thank you, Lisa and Cindy. Attorney Bannon.
Thank you. I just want to clarify for the board that the board does not have authority to modify consent orders. The board can approve or reject a consent order, and in your discussion, you can make recommendations to respondent and the department to potentially revise a consent order, but the board cannot itself modify a consent order.
Got it. So the discussion can include what we think would be more agreeable, but we cannot change it. Any other thoughts on this consent order? Oh, is Sal back? Sal?
He recused himself on this case.
Oh, okay, sorry. Sorry. Okay. Okay, so hearing no further discussion, we're going to take a vote on this consent order as written. And the motion on the floor is to approve it. Let's see. Sal is recused, so we can mark that. Lisa Freeman.
I vote not to accept it.
Okay, so nay. Susan Yan.
I'm gonna abstain.
Abstain. Cindy Arpin.
Aye.
Camille Payne.
Aye.
Diane Whitley.
Aye.
And I, Mary Deepman, vote aye. So the consent order carries or is approved. Attorney Brown, any questions?
Thank you. No questions. I appreciate it. He won't let you down.
All right, you are welcome. Thank you again. All right, let's move on to the next consent order, which is Sabrina Marcelino, RN. Petition number 2025-800. I'm assuming Attorney Kataya, as she said, is going to take this for Anthony Nanny. And I know she's here, and I know Attorney Brown is here because I see him. And
good morning.
Good morning again. And is Sabrina Marcelino on the call as well?
Unfortunately, she's not, because she's actually on her way to Argentina for a long scheduled meeting with her family.
Okay, thank you. I'll allow you to speak in a moment. I'm going to ask Attorney Kataya first, okay? But thank you for that. Attorney Kataya?
Yes, Madam Chair, this is the matter of Sabrina Marcelino, registered nurse, in petition number 2025-800. She holds registered nurse license 137544 and does not hold an advanced practice registered nurse license. The allegations herein are that between April 6, 2023 and July 31st, 2025, the respondent provided certain treatments and services to patients that were beyond the scope of a registered nurse, that would have required licensure as an advanced practice registered nurse, and would also have required to be performed under the supervision of a licensed medical professional authorized to prescribe the services and treatments. She has since ceased those activities. The consent order being proposed would again add to the order a cease and desist, that she would cease and desist any activities that would require licensure as an advanced practice registered nurse, that would apply a reprimand to her registered nurse license, impose a $5,000 civil penalty, and require that within 6 months of the approval of the consent order that she complete coursework in, I believe, ethics and scope of practice. The department requests that this consent order be approved as proposed.
Thank you, Attorney Kataya. Attorney Brown.
Yes, thank you very much. This is a person who has no prior history with the department, and I doubt there'll be any history going forward. This is an ambitious young woman who has over the years not only obtained her license as a registered nurse, but has been working hard to get her APRN. She took all the relevant courses, and that she actually passed the exam, and but however, it didn't register appropriately with her. That's interesting, but unless you are an APRN, you can't behave as if you were. As a result of that and our discussions, she decided to take the course without any conditions. It's called the Certificate of Completion by one of the online entities that provide this. And she took in the question of scope. It was 5 hours worth, and I think I know I provided to the board proof of successful completion of those 5 hours. And while it would not count towards what she needs to do moving forward, the reason she took it was she's very apologetic. When this was pointed out to her, she immediately stopped. There's been no claim whatsoever that she in any way attempted to continue this inappropriate behavior. The board saw fit to reinstate her, but is demanding a $5,000 fine. I can assure you that was a lot of money for her, but she did borrow and do what she needed to do to come up with that money. She's also made it clear to me to make it clear to you that she apologizes for her misconduct, that that this will not happen in the future. She's learned a valuable lesson. I think she's a terrific nurse, and I think down the road, if she completes other qualifications, she can improve by becoming an APRN. But for now, she wanted me to state the apology, let you know she's taken it very seriously, and assuring the board that it'll never ever happen again. Thank you.
Thank you, Attorney Brown. Board members, is there a motion, or can I please have a motion on this consent order?
This is Cindy. I make a motion to affirm the consent order for Sabrina Marcelino, RN, petition number 2025-800.
Thank you, Cindy. Second?
Second, Lisa.
Thank you, Lisa. Discussion, board members. Oh, Sal, I'm sorry. Your hand is
That's
up.
okay,
Go ahead.
Mary. Hi, yes. So I have a concern with this because I do understand scope of practice. Sometimes people could forget the scope of practice, or sometimes practice outside the scope of practice accidentally. And she went for that class, but she represented herself as a nurse practitioner. So I have an integrity issue here. She lied. So how do we know she's not going to do that again? So integrity is big. And again, we as nurses know we can't misrepresent ourselves as an APRN if we're not an APRN or whatever. And she did intentionally misrepresent herself. And so to me, this is not an error or a slip in knowing the scope of practice. This was an intentional thing she did. And so I have an issue with integrity. And I went back and forth on this in my head. While I've always had, usually for integrity, I don't tolerate it. But I don't think in this case, I would go for revocation. But I think her fine should be much higher than it is. Because to me, this is very serious. It's an integrity issue. And, my experience has, when somebody has an integrity issue, that continues. But that's just my feedback on this.
Sal, thank you for your comments. Other board members? Cindy.
I'll just add that I agree with Sal. Attorney Brown stated that she went through schooling to be an APRN, so she should have known even more than the average nurse what the scope of practice was, and blatantly, went outside of her scope. So I do agree that perhaps it needs to be more. I'm looking more at, I think a 6-month probation is pretty, that's a small amount of time. Perhaps a longer probation, and in addition to a higher penalty if that's what is decided by the attorneys.
Cindy, thank you. Are there any other comments from board members or discussion?
This is Lisa. I just want to say that I completely agree with both Cindy and Sal in terms of the intentional behavior and the danger of somebody practicing outside of their scope, full well knowing that that's what they were doing. And I think that the suggested remedy that Cindy has put forward is very appropriate.
Thank you, Lisa. Other board members, anyone else? Hearing none, we'll take a vote on the motion to affirm this consent order. Sal Diaz,
Nay.
Lisa Freeman,
Nay.
Susan Yan,
Nay.
Cindy Arpin,
Nay.
Camille Payne,
Nay.
Diane Whitley,
Nay.
and I, Mary Dietman, vote nay as well. So the consent order is not affirmed. So Attorney Brown and Attorney Kataya, good luck.
I would like to ask for some additional clarification on the recommendation for a longer period of probation. The current probation terms require only coursework. Are there additional terms that you wanted to see or just a longer probation?
This is Cindy. I was just thinking a longer probation to keep a closer eye on this nurse for a bit longer, perhaps, a year.
And I think she should take an ethics course. And a higher fine.
So we're hearing ethics, higher fine, Sal just said, and a longer probation. Attorney Kataya, is that helpful?
Yes, thank you.
You're welcome. Attorney Brown, anything?
I believe I got the message. I'll deal with it.
Thank you. Okay, I'm sure you will. Thank you. Next matter. Jackie Lamity, I'm sorry if I am mispronouncing your name. RN petition number 2025-1481. Staff attorney, Attorney Fazina. Are you on?
Yes, good morning. Attorney Fazina is present.
Good morning, thank you. First respondent, then I'll say counsel, is respondent on?
Yes, I'm on.
Thank you. Good morning. And your counsel is here as well. Attorney Patrick Monahan.
Yes, I am here. Thank you very much.
Thank you. Okay, so we'll start with Attorney Fazina, and then Attorney Monahan will have a chance to speak.
Yes, so this matter was originally before you at your May 20th meeting where you rejected a proposed consent order that included a reprimand and a civil penalty. And at the time, there was an indication that the proposed consent order should include coursework. So the revised proposed consent order before you today includes a reprimand, a $1,000 civil penalty, and a 6-month probationary period to complete courses in scope of practice, documentation, and medication errors. And the parties respectfully request that you approve the proposed revised consent order. Thank you.
Attorney Fazina, thank you. Attorney Monahan, would you like to speak?
I would thank you very much. I would simply like to say that that was an accurate description in my part, from my point of view, that Attorney Fazina just described. And on behalf of Ms. Lamity, we, willingly went with the recommendation of additional education and a probation, a concurrent probationary period that was recommended with that. But we respectfully request and hope for favorable consideration.
Thank you, Attorney Monahan. Board members, may I have a motion on this consent order?
This is Lisa. I motion that we accept the consent order as currently written.
Thank you, Lisa. Second?
This is Cindy. I'll second.
Thank you, Cindy. Okay, board members, discussion, please. If any. Sal, you have your hand up?
Yes, again, I hate to be the fly in the ointment. But on her application, her renewal in Connecticut, she checked the box. I'm assuming since she didn't admit to it, she checked the box no, that she didn't have any reprimands or any pending litigate or whatever the question is. To me, that's an integrity issue again. You knew what happened in Massachusetts and you chose to omit it on your renewal. And again, this is scope of practice, something you learn that you're supposed to do. So I have an integrity issue, unfortunately, for this because of that. That's an intentional, not. It's not like she didn't report it and she didn't renew her license yet, so she didn't see the question. She didn't report it. She saw the question and didn't answer the question. She wrote, I'm assuming no is the answer she put on the thing, which again, she knew her license had been reprimanded in Massachusetts. But that's, again, my feedback.
You are correct in that the answer no is troubling. Are you okay? Other discussion before I give my thoughts, I guess. Other discussion?
This is Cindy. I'm sorry. Am I allowed to talk?
No, with all
Yes,
due
you
respect,
are.
I wait.
I'll be
if-
quick.
If I have an appropriate time to talk, I will await my turn.
I will, okay, so we're gonna have board discussion, and then as soon as the board members are done, I'll ask Attorney Bannon if we can take a vote or if you could have an opportunity to talk, okay? Thank you. Thanks. Cindy.
Okay, and I raised my hand this time. I apologize for not doing that.
That's okay. I
okay.
see you.
All right. I agree with Sal that it's an integrity issue. I will, however, state that this did come to us before and we asked for courses to be added, which have been added. So I don't want to keep going back and forth with this respondent. So I'm comfortable with where we're at, but I certainly respect Sal's thoughts on this as well.
So I'm thinking the same thing as you, except was that fine? I can't remember it. I don't, is that, was that fine on the original one, Cindy? 1,000? To me, that seems low.
I honestly
But
don't remember. Perhaps Attorney Fazina can refresh us.
Yeah, and if it was there to begin with in May, and then I'm not gonna say, I want to see it higher now. Do you know what I'm saying?
The only change that has been made is the addition of a probationary period for the coursework. The fine and the reprimand were on the prior consent order that was rejected at your May meeting.
And so we didn't note it at that time, is what you're saying.
Correct.
So I would feel unfair then at this point to go back to that, but that's just my opinion. What a further discussion from board members on, and yeah, Sal?
So I think an ethics course at the very least needs to be added. It is not one of the courses that is outlined. And again, I would go higher on the civil penalty, but I understand what people are saying. I don't believe I was at that meeting for some reason, or I might have had to leave early. I don't remember this case.
Thank you, Sal. Any other board members? Attorney Bannon, may I allow Attorney Monahan to speak before we take our vote, or no? Is that not allowed?
I think he can say something, yes.
Okay. Sorry, Attorney Monahan, I have to ask it for, to make sure we have the correct protocol, but please go ahead now.
Thank you very much, and I appreciate the comments of all the board members. And I would just simply like to, on behalf of Ms. Lamety, point out that for your consideration, we did come prepared last time. We have willingly, without any contest with DPH or this board, um, um, gone with the additional education and the probationary period required. I'd also like to point out that I do believe that there should be some consideration that this matter did emanate some years ago from an out-of-state issue. And I do know that Connecticut is focused on Connecticut, as it properly should be. But Ms. Lamety has for the initial wrongdoing that gave rise to where we are today, taken a number of courses, paid fines in previous situations, and of course paid a number of different expenses and fees, and is quite remorseful for the fact that she is now dealing with perhaps the sixth year of a very significant mistake in her nursing career. With respect to the checking of the box of no, I do think I can, after meeting with and discussing this with Nurse Lamety and understanding her situation, I believe that this was not an intentional, let me see if I can get this by the Connecticut board. This was after a very, very rigorous and intense, I'll say, dealings with the Massachusetts board to obtain her licensure and going through a consent order, and about a South Carolina matter. And very candidly, I believe in her mind, based on her representations to me, she believed the matters were over, and while the correct answer was obviously a yes, it was not an intent to deceive. It was perhaps a feeling of relief when Massachusetts was over, and that carried over into either certainly not intent, but perhaps carelessness in that. I understand the board members' concerns about ethics and integrity, but I can assure you that Ms. Lamety has learned a lot of lessons through this, and I would hope that that kind of consideration could be at least taken into account.
Attorney Monahan, thank you for your comments. Board, any further discussion before we take a vote? Or should I allow Attorney Fazina to speak, actually?
I have nothing to add. Thank you.
Thank you, Attorney Fazina. Any discussion from the board members before we take a vote on this consent order? Hearing none. Sal Diaz.
Nay.
Lisa Freeman. Oh, did she leave? No, it's 9:30. Well, she was gonna leave at 9:30. Is Lisa gone? I can't, have to pull up the participants to see. Brett, do you know if Lisa's gone?
She's in the meeting.
Okay.
It looks like her sound isn't working.
Okay, I'll come back to her to see if she can get that working. Susan, Jan.
Nay.
Cindy Arpin,
Aye.
Camille Payne. I'm sorry, I didn't hear you, Camille.
Aye, sorry.
That's okay. Thank you. Diane Whitley.
Aye.
Lisa Freeman, are you able to speak? Not hearing Lisa, I will vote. Mary Deepman, and I vote aye. So the consent order is approved. Attorney Monahan and your client, I believe she's not on, right? Or she is?
I am on.
Okay, so the consent order was approved.
Thank you.
Thank you. Have a good day.
Thank you.
Okay, so we're going to move on. It looks like Attorney Menschel is here. So we could go back to number 4, if that is okay, Attorney Bannon.
That's entirely up to the board if you'd like to take up number 4 right now.
Board members, are you in agreement? Just a verbal aye or nay? Oh, I don't hear any objections. So let's go back to agenda item number 4, proposed memorandum of decision and supplemental briefs with, and this is a continued discussion, as I said earlier, from 2 previous meetings on Rochelle George RNA PRM petition numbers 2025-299 and 2025-298. Attorney Fazina, I see that you are present. Attorney Menschel, did you
Yes.
fare the traffic? You're here?
Yes, I appreciate the board's moving this matter back to allow me to make my way through the hour and a half it took me to make a 20-minute trip. So I appreciate that. Thank you.
You're welcome. Connecticut traffic is tough, but that's because everybody wants to live here. Rochelle George, are you present?
Yes, I'm here.
Okay, thank you. Okay. So I guess I should allow the attorneys to speak, or can we jump right into where we were in terms of the statement of charges last meeting?
So Mary, if I
Attorney
may,
Bannon.
this is Liz Bannon. I think what I'd like to do, if it's okay with you, is just give kind of a brief summary of where we are. And part of this is so that everyone's on the same page. And also it's an education moment for our newest board member. So this is, go ahead.
Sure. I'm sorry, I didn't mean to interrupt you. Sure.
Not at all. So this is a proposed memorandum of decision that was presented to the board 2 board meetings ago, I think for the first time on June 3rd. Based on some of the conversations, the parties, Attorney Menschel and Attorney Fazina, submitted briefs on 2 specific issues for really legal issues for the board's consideration with respect to the process and how the board handles proposed decisions presented to it by a hearing officer, as well as an issue with respect to the board's specialized knowledge. There was a lengthy discussion of the briefs, and I had advised the board that under these circumstances, it has 3 options as to how to proceed with respect to a proposed decision. One of those options is to approve the decision as presented. One of the options is to modify the decision as presented, and one of the options is to remand the decision. Under these circumstances, it would be to the hearing officer. Just again, for kind of educational purposes, if it had been a proposed decision presented by a panel, a remand would go to the panel. With respect to the board's specialized knowledge, the UAPA, that's the Uniform Administrative Procedure Act, does allow a board to rely on its specialized knowledge. And under these circumstances, what we had begun to do at the board's meeting on June 17th was to identify the paragraphs in the statement of charges as submitted by the Department of Public Health the conclusions of the hearing officer that the board either agreed with or disagreed with. And per my notes, and I welcome anyone to correct me if I'm wrong, but per my notes, we had established that paragraphs 1, 2, 4, and 5 of the statement of charges had been admitted to and therefore were not contested. So we did not need to address those. And again, just for the purposes of today's proceeding, the statement of charges I'm referring to is that which is dated August 11th, 2025, and consists of 9 numbered paragraphs. At the last meeting on June 17th, the board had begun its discussion of the hearing officer's conclusions regarding paragraphs 3, 6, 7, and 8. The board had in its discussion, and I should also note that what I had advised the board is to, if it's disagreeing with the hearing officer's conclusion, to cite to the evidence in the record, that is the either testimony adduced at the hearing under oath or the documents that had been entered as exhibits, to cite to that evidence as support for the board's conclusion. And the board had begun that process. The board had agreed with the hearing officer's conclusion as to paragraph 3, that the department had met its burden of proof. That burden of proof is a preponderance of the evidence, essentially more likely than not. Sometimes we say 51% likely that it's been proven. The board had engaged in a discussion with respect to paragraph 6. The board had discussed specifically in my notes, among other things, Exhibit K and the transcript from Ms. George's own testimony. And the board had concluded that it disagreed with the hearing officer's conclusion and instead found that based on the evidence the board had discussed, that the department had met its burden of proof with respect to the allegations in paragraph 6. If I am mistaken in anything I just represented, I encourage both board and council to speak up. Otherwise, I would encourage the board to resume its discussion, picking up where it left off with respect to paragraph 7. And I am happy to myself read the allegations in paragraph 7, or if someone else wishes to do so, that's appropriate as well. I defer to the board.
Thank you. That is exactly what I recall as well after reviewing both meetings, the video, the transcripts, that we were at 7 and that we needed to do 8 as well. Just look at 9. I'm sorry. What is 9 again? Oh, yeah. Okay.
And yes, you're right.
Um,
And Mary,
you
if I
gotta do
may,
that.
so 9 is essentially if the board concludes that the department met its burden, 9 would require the board to determine whether the conduct warrants discipline, and if it does, what discipline would be appropriate. So we can get to 9 at the conclusion of this process.
Right. So we have 7, 8, and 9 to do.
Correct.
Okay, got it. So
And
number 7. Yeah. go
And
ahead.
before we begin, I want to just establish, and if it doesn't need to be a vote, but just a verbal affirmation from board members that those who are participating in this exercise, this process, just please acknowledge whether you have read the record in its entirety. So that would be the transcript and all of the exhibits, as well as, if you weren't present at the meeting on the 17th, just affirm that you have watched the video. I want to make sure that the board has the universe of evidence in the record before it.
Aye.
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 Okay, so for the record, that was, can we do that again and have people say their names, please?
Mary Deepman, aye.
Sal Diaz, aye.
Cindy Arpin, aye.
Diane Whitley, aye.
Susan Yan, aye.
Camille Payne, abstain.
Okay.
So Camille is abstaining. Lisa Freeman is, I believe, off the meeting. So let me just, would we need it, if someone abstains, they still count in the quorum though, correct? Yeah,
That
so
is
we're
correct,
good.
Mary.
Okay,
Correct.
just want to make sure. Okay. Okay, so let's pick up with number 7. Attorney Bannon, in the last meeting, you did read each one, so take it away. Read that, number 7.
Sure. I do see before I begin, Brett has
Brett.
her hand up.
Yeah, I'm sorry to interrupt. Yeah, Brett, go ahead.
Yes, so Lisa is present, but it seems as if she has no sound. So I'm not sure.
Did she chat with you and say I'm present, or is she
I can
just?
see her on video.
Oh, I don't see her. Hold on, I don't see her on mine.
Hi, Lisa.
Oh, there. No, I see Camille. Where's Lisa?
Lisa, do you want to try logging out and logging back in quickly? Sometimes I find that helps.
Mary, at the bottom of your screen, hit the arrow. It changes the screen over to the next set of people on.
Yeah, that's what I'm doing. I'm going through
Oh.
all of them. And
Yeah, I see her. Now she's not there anymore, but she was there.
Are we waiting for Lisa, or because I thought she was going to be gone from 9:30 to 10:30, but if you saw her, then
Well, this is Liz Bannon. I had just told her maybe to try logging off and logging back on, so that might be what she's doing. So if we want
Give
to
her a
wait just
minute
one
then.
moment.
Sure.
And Mary, I believe she's going to be leaving the meeting from 10:30 to 11:30.
Oh, yeah, that's right. That's exactly what I wrote down. Sorry, Brett.
That's okay.
So she didn't vote on our last consent order, and she was here because we couldn't hear her.
I've added her to the, okay, let me see. It looks like she's signed in, but I don't see her yet.
Okay. Well,
Are you able to hear me now?
yes.
Yes.
Hey.
Thank
Were
goodness
you
for cell
able to
phones.
hear, Lisa, were you able to hear everything regarding this matter of
I did.
Rochelle? Okay.
Yes.
And did you,
Yeah,
and did you
I've gone.
affirm? Sorry,
Yes,
did you
I can affirm.
affirm that you have viewed all the hearings, transcripts, and exhibits in this case?
Yes, I have.
Thank you, Lisa.
Thank you,
Okay.
Lisa. Thank you, Mary.
Sorry about that.
No problem.
No work. Go ahead. Sorry.
Okay, so let us resume. I will read paragraph 7 of the statement of charges. Respondent claims to have completed the required program hours and or clinical training required to complete and or graduate from a pre-licensure nursing program when respondent knew or should have known that claim to be false. So again,
Thank you,
when the board discusses this, please, cite to the evidence in the record to support your conclusions.
Thank you, Attorney Bannon. Board members, discussion on number 7.
So this is Sal again. I think same with number 6 is that using Exhibit K, the transcript, and using her testimony that she did not complete any clinical hours at MedLife Institute, and looking at the amount of hours and what she said she completed, it was page 242 of her transcript, did not complete clinical hours. And then when we look at Exhibit F, which is answers to the questionnaire that was sent her, I believe, response to follow-up questions. She put that she attended 3 times in April, May, and July for 3 days each, for 24 hours each time. She did have in May that she stayed 4 times, but that was 1 day was for her party. And so that's only 72 hours. She got credit for more than 72 hours worth of work on this transcript for them and received a grade for clinical. And she had said she did not complete any clinical there in her testimony. Also, question number 9 on her questionnaire, she says, how did you receive your online instructions? She says online instructions was delivered by professors through the Blackboard platform, submitting and completing assignments. So the assignments were instructions, and as far as I know, MetLife was not approved to do online courses, so she could not have completed the required coursework. So in the first part, the claimant, she did not do the required training, but I can't say. I guess I'm assuming that if she looked at her transcript, she would have saw that she got credit for a clinical that she knew she did not complete and should have had that transcript corrected. And so again, so I can find for number 7. And Attorney Bannon, did I do that correctly? The way that we're supposed to?
You did, Sal. Thank you.
Okay, thank you.
Not only that, that was very thorough. Sal, I agree with you that the department has met the burden. But I want other board members to weigh in as well. Anyone have anything additional to add or discuss on number 7?
This is Cindy. I have nothing additional, but I just want to say I absolutely agree with Sal. And thank you for doing such a thorough job.
Yeah, Sal. Do we take a vote on each of these, correct? Or are we doing that at the end?
I believe we had discussed doing that at the end. So this is discussion purposes, and then the board will vote whether it's planning on modifying, approving, or remanding the decision.
Okay, so if any, once again, any other comments before we go to allegation number 8? Okay, then let's move on to number 8. You want to read that, Attorney Bannon?
Certainly. Paragraph 8. Respondent's licensure as a registered nurse in the state of Connecticut resulted from the providing information and documentation to the licensing authorities in Connecticut, leading those authorities to conclude that respondent completed the required program hours and or clinical training to graduate from a pre-licensure nursing program when, in fact, respondent did not complete the required program hours and or clinical training.
Okay,
So
discussion. Go ahead,
I think 8 falls under the same thing of she did not complete the clinical hours that is shown on her transcript, which we would have made a decision based on that for licensure. And she had online courses, as I had stated before. And then she even said in her testimony that she took all her clinical instruction at Helen Fold, and she also answered that on question number 16 and 16A of the questionnaire. I forgot to mention those 2 areas of where that was. So again, she did not meet the requirements of program hours and or clinical training.
Thank you, Sal. Again, that was thorough and just of note that, yes, it is in multiple places in the record. So you mentioned you didn't, cite that last fact, but that was in the record. So I also agree with you that the department has met that burden, but I'd like to hear from other board members as well.
This is Lisa. I do not have anything to add. I think Sal, you were very complete and specific. But I do agree with this point. So
Thank you, Lisa. You were a little broken up in terms of your connection, but I think we could all hear what you said. Anyone else? Okay, then we will move on to number 9.
This is Liz Bannon. Paragraph 9 of the statement of charges reads, the above cited facts, evidence, conduct that fails to conform to the accepted standards of the nursing profession because respondent did not successfully complete the necessary requirements to obtain a nursing degree, and they therefore constitute grounds for disciplinary action pursuant to Connecticut General Statutes sections 19A17 and 20-99, including but not necessarily limited to Connecticut General Statutes section 20-99 subsection B.
Thank you, Attorney Bannon. Board members, discussion on number 9. Cindy, sorry.
I would just refer to all of the testimony that Sal has given for the other items. It all falls under this. We can prove this to be correct.
I'm in agreement as well. If 1 through 8, we believe was the department met the burden, that stands with number 9 as well. But I'd like any further discussion to be allowed by the board before we take a vote, or before we accept a motion is what I should say. Hearing no further discussion, I would like to ask a board member to make a motion, and the options are to approve, modify, meaning the board can modify, or remand, meaning this would return to the hearing officer. Those are the 3 options, correct, Attorney Bannon? Anything to add to that?
So you are absolutely correct, Mary. Those are the 3 options. I do want to note, however, based on the board's discussion of the evidence, that if the board votes to modify this decision, it may be necessary to nevertheless remand to the hearing officer. And the reason for that is that Attorney Menschel had filed what are called special defenses. And this is a legal, essentially legal arguments. So if the board, why don't we do this? I will address that kind of second piece to this. And my proposal to the board would be to bring a motion to the floor and have a vote as to kind of how to address the proposed memorandum of decision as you have it presented to you. So I would propose either voting to approve it, voting to modify it to reflect the discussion you just had, or voting to remand it. And remand would be to the hearing officer to take additional evidence, essentially.
But what you're saying is no matter what we do, it's going back to the hearing officer, or that needs to be considered on your end?
Unless you vote to approve the proposed decision, I think if you vote to modify or you vote to remand, yes, my recommendation and advice to the board would be that it will go back to the hearing officer one way or another. But we can take this step by step.
And we'll get to vote on that?
Yes.
And if I can just inquire as to at what point, Attorney Bannon, that you will be allowing me to do the rebuttal.
Certainly. So here, I think The board, in its discussion right now, has indicated that it disagrees with some of the hearing officer's findings. So presumably the board is going to be voting to either modify the decision or remand it to the hearing officer to take additional evidence. Attorney Menschel, as I indicated, had filed or had raised 2 special defenses to the allegations, which the hearing officer did not address in this decision because he found that the department had not met its burden with respect to several of the paragraphs in the statement of charges. If the board is essentially disagreeing with that, the hearing officer will then need to consider the special defenses because they've been filed and they warrant consideration. So that will be that's kind of the path for the board going forward. And Attorney Menschel, I think, if I can just have a moment to think about, I do believe that yes, of course, you should have an opportunity to be heard.
If I may, I can elaborate a little bit more on my view of, and then of course Attorney Fazina can put in her view, but as to why and when I think I should be able to be heard.
Certainly, I welcome that. Yes, Mary.
Attorney Bannon, a point of order. I just, we were required to listen to both of the transcripts of the previous meeting. So if there is no new information regarding the record, not sure, I'm not understanding why there needs to be further discussion from the attorney.
I think that is a very fair point, Mary. I think that the issue here is that, this is a relatively new process and, this was a proposed decision that, the board is essentially has discussed, and its discussion has indicated it disagrees with some of the findings. So I think that under these circumstances, it may be appropriate to hear essentially argument from Attorney Menschel. It's not an appropriate time to hear additional evidence.
Okay, because we certainly want due process, but we have, as you said, we have not done this before. And I believe some of the items coming up on the agenda towards the end have been continued from previous meetings. So if this is going to take up the rest of the meeting, or most of it, I just want to note that
and completely understandable. I will note also, though, that this has been continued twice too. And so I think that there's an interest, particularly for Ms. George and her attorney and the department, in resolving this today, if possible. So to that end, Attorney Menschel, I do think that it's appropriate for you to make argument if you're prepared to make some argument, Attorney Fazina to make argument if you're prepared to make argument, but being cognizant that, it's limited to argument, not additional evidence.
And should we do that now, or do we make a motion and take a vote and then they speak? I guess they need to speak first, correct?
Why don't we do that now?
Okay, and which attorney do I call to speak first? Probably Attorney Menschel, or do you have is there a protocol?
Well, Attorney Menschel, why don't you go first, then Attorney Fazina, and Attorney Menschel, you can have a couple of minutes for a response if needed.
Okay, Attorney Menschel, go for it.
Okay, thank you. Well, first of all, I object to this whole process because, as Attorney Bannon pointed out, what you can do is look at the evidence. But in this instance, we're getting new evidence. The department had a very simple and specific allegation and set of evidence that they put into the record. They put in that the Tannis affidavit said that if anyone did not reside in Florida, then they did not earn their degree. The department put on a witness who was not a nurse and testified that Rochelle George did not live in Florida, therefore she did not earn her degree. The hearing officer correctly, he was a lawyer and not a nurse. I understand that. The lawyer said, well, there was not enough proof because the fact is she traveled to Florida, attended all the classes that she was intended to take or required to take by the school that was accredited by Florida, and she fully and completely made disclosure to the Connecticut Board of Examiners, obviously not made up of this group of members, but the Connecticut Board of Examiners for Nursing and DPH were told specifically that she went to MedLife Institute and she attended all the classes in person that she was required to. And the courses were in person, not online. The homework, just as every person probably in this room didn't do their homework in the classroom. They did their homework at home. And that's what the use of that online material was used for. It was for homework assignments. In the old days, you'd write it out in person. That's what the transcript shows. That's what the hearing officer found. And found in favor of Rochelle George. She disclosed MedLife Institute to DPH, not just on her application. She disclosed it every year for 8 years. And so she fully and fairly told DPH exactly where she went and what courses she took. She then passed the NCLEX exam, which is what this board and boards all across the country use as the measuring stick for whether someone has the qualifications or not. She practiced for 15 years with a spotless record as an LPN, an RN, an APRN. She's not somebody who just paid amount of money and got a diploma and that was the end of her education. To say in paragraph 3 that she got her nursing education from MedLife Institute is totally inaccurate and completely unsupported by the evidence in the record. She got her degree there. She didn't get her education there. Most of her education came from Helene Fold. Most of her education came from other sources. She didn't just take her diploma and go away. She went on, she got her BSN based on the fact that she had gotten her RN license. She got her APRN license after getting her master's degree. She's 3/4 of the way through her doctorate. This is somebody you should be celebrating, not trying hell-bent for leather to revoke her license. The fact is, as Attorney Bannon explained to you, before you can get to discipline, the board needs to determine there is a preponderance of the evidence to establish that a respondent engaged in conduct that warrants discipline, right? So you can get to step B. You cannot get to step B without step A. So you've got to ask yourselves, what is it that Rochelle George did wrong? She went and got her degree after checking, and that's what's in the transcript that you're not looking at and not pointing to. She went and did a check and made sure that MedLife Institute of Naples was accredited, which it was. It was accredited by the state of Florida. The Connecticut Board of Examiners of Nursing and the DPH fully vetted Florida, Naples, the MedLife in Naples. It took months before they approved her to sit for the NCLEX exam. She took the NCLEX exam. She passed the NCLEX exam. What did she do wrong? She told everyone who needed to know that that's where she went. They had a full and fair opportunity, which you're also ignoring in the transcript, that the fact is that there were statements by both by two people, Kathy Boulware and Christian Andreessen, who said that no one, because other people other than Rochelle George were denied access to taking the NCLEX exam. Those people made statements at the time that that no one gets to take the exam unless the department and the board is satisfied with the integrity of their education. So now, 10 years later, a whole different board is coming to a different conclusion and saying that Rochelle George should have known what the Florida board obviously did not. And when the Florida board did get to take away the accreditation, it was 3 years after Rochelle graduated from there, and not because it was a diploma mill. It was because their people did not pass the NCLEX exam at a high enough rate. So it wasn't even that there was something wrong with the education she got. She got the same education that people who resided in Florida received. And that's one of the things the hearing officer found. So if you're going to try and modify this decision, then that should go back. It shouldn't be modified. It should go back to the hearing officer. He fully and fairly examined it and found in Rochelle George's favor, and that should continue to stand. And as Attorney Bannon suggested, and in fact it's absolutely correct. The fact is that we did not get to put, none of this evidence was in front of the hearing officer. So in terms of what, Commissioner or Board Member Diaz and the others have said is their understanding of how things should work. The department had its opportunity to do so. They didn't. They put on one witness who was not a nurse. And the people who allegedly were misled by Rochelle George were available. They still work. A number of them still work for the department, and they didn't put those people on as witnesses either. So in some, you talk about, and the other thing the hearing officer did not get to rule on or propose was the level of discipline, even if you were to reverse his decision that the department had not met its burden, then the hearing officer should have had an opportunity, not only as he had to, because he ruled on the legal issue, and he's a lawyer, and found that we were entitled to present our case for promissory estoppel, because the department waited 10 years before they decided there was something wrong with Rochelle George's associate in nursing degree, and then pulled the rug out after she had incurred substantial expenses going on for her bachelor's, for her master's, and 3/4 of the way to her doctorate, in order to fulfill her lifelong dream of being a nurse and helping people. And that's, again, in terms of arbitrary and capricious, you've heard cases before that where people have actually, nurses have actually hurt people, sent people to the hospital because of their mistakes, had repeat offenders, and they didn't lose their licenses. Rochelle George has done absolutely nothing wrong. She's done everything everyone has asked of her and completed her education and is 3/4 of the way through for her doctorate, when now all of a sudden 10 years later she had something wrong because she got 1 C out of her whole career at Helene Fold, got credit for those courses, but didn't get her degree there. And so you talk about arbitrary and capricious. You want to revoke a license for somebody who's devoted her life and her life savings to nursing and should be celebrated by this board and not have her license revoked. Thank you.
I'd like to say thank you for that, but the arbitrary and capricious is preventing me. So is the next thing on the agenda Attorney Fazina?
Yes,
Thank
Attorney
you.
Fazina may have an opportunity to be heard. Linda, you're muted.
I'm sorry. Well, my understanding was that, you know, there were specific issues that the parties were asked to brief, which we did, and submitted them before the, I think we had to submit them by June 12th for the June meeting. As at this point in the process, as I understand it, the board hasn't even taken a vote on a remedy, and it sounds like Attorney Menschel is disagreeing with their discussion today regarding certain findings that the hearing officer met. But as was briefed, the board has the final decision-making authority, and it's also the department's position that they can rely on their specialized knowledge in interpreting the evidence that was presented. And I thought I heard a vote earlier this morning that those present today confirmed that they've read the transcripts, they reviewed the prior meetings where this matter has been taken up, and that they've also reviewed all the documents. So, and some of what I'm hearing from Attorney Menschel today, it sounds like is arguments that we were asked to brief as part of the promissory estoppel defense. There was an additional day of hearing taken on those issues, and I believe Attorney Bannon has correctly noted that wherever the board ends up, that those special defenses will have to be taken up in any revised decision. But I'm not, you know, those issues were fully briefed. Actually, I believe I don't remember off the top of my head when the additional day of hearing was scheduled, and the hearing record was kept open for the parties to submit briefs, which was done, I believe, sometime in March of this year. So I'm not going to reiterate all of that for today. Thank you.
Thank you, Attorney Fazina. Attorney Bannon, can you please advise us on how to proceed at this point?
Sure. I would like to allow Attorney Menschel, you know, one last word if he so chooses. Otherwise, I would advise the board to present a motion on how you wish to proceed with the proposed decision.
Attorney Menschel?
Yeah, just very quickly, the reason why I made this argument is because, and again, part of the procedural problem is this was not done as part of the hearing. As Attorney Bannon has suggested, the hearing is closed. The evidence has been submitted. We're now, and under the Feinstein and the United Jewish Center and all of the case law, that if the board is going to use its own expertise, we have to have had notice of it, which we did not, and we had to have an opportunity to rebut it at a meaningful stage of the proceeding. And so this whole procedure is in contradiction to that, but to the extent that we're being made to go through it, that's the reason why I had to bring these arguments up at this time. And I do not agree that I'm waiving those arguments. I'm simply responding to what the board is putting before us.
Thank you, Attorney Menschel. Is the board now prepared to make a motion, or are there questions for Attorney Bannon before we proceed? Sal, are you trying to make
Yes,
a question?
I have a question for Attorney Bannon. I thought last time when we met, we did give notice to him on the meeting. I'm seeking clarification. Secondly, on all my things, have pointed specifically to Rochelle George's testimony and or answers to the questions. And so I have looked at that and seen that she said she didn't complete clinical at MedLife. That's what she said multiple times. But on her transcript, it shows she completed clinical at MedLife and got a passing score. So, Attorney Bannon, I thought we did give notification, but I also want to say I'm just in reading the transcripts. I'm looking at the exhibits, and they don't match.
And so Sal, to respond to your question, what the, and board members, correct me if I'm wrong, but the board has used its own expertise and technical competence in the evaluation of the evidence in the record before it, which was appropriate. So at this point, I am happy to assist the board in crafting a motion. So, I mean, it sounds like the board in its discussion has disagreed with the hearing officer's conclusions that the department did not meet its burden by a preponderance of the evidence with respect to paragraphs 6, 7, 8, and 9. And the board agreed with the hearing officer's conclusion with respect to paragraph 3 that the department did meet its burden. So based on that and the board's discussion of the evidence through the lens of its expertise and specialized knowledge, the board can make a motion to modify the decision to reflect the fact that the department had met its burden with respect to all paragraphs of the statement of charges. And as I had discussed earlier, that would then require the hearing officer to consider the special defenses, which were not addressed because he had found that the department had not met its burden. So my advice to the board would be to vote to modify the proposed decision to reflect that the department has sustained its burden with respect to all allegations. And based on that, you should have a discussion about remedy. But there needs to be a piece of that motion where you remand it to the hearing officer with an order to consider the special defenses raised by Attorney Menschel.
So do we have a motion?
Okay, so this is Sal. I motion to
modify.
To modify, as I believe that they've met the burden of proof, and
with respect to all allegations.
With respect to all allegations, and that it goes to. Is that it for right now, or you want me to put the remand? Go back to to listen to the special.
So I think that and to remand to the hearing officer with a direction to consider and rule on the special defenses.
That would not be remedy? That would not be under remedy?
I think you should engage in a conversation with respect to remedy as well.
So it should be included.
So do we do the conversation first and then do it? Or
So here, let me explain special defenses for a moment. So a special defense, as Attorney Menschel has raised, he had raised, I believe, promissory estoppel and latches. Correct me if I'm wrong, Attorney Menschel. But those are two legal arguments that the hearing officer would need to consider. And for example, if he were to agree with Attorney Menschel on either or both of those special defenses, it would essentially say, the department has met its burden of proof, but nevertheless, the respondent has kind of stopped the respondent shouldn't be penalized because here are some defenses that would suggest she shouldn't be penalized. So the hearing officer needs to make a decision with respect to the special defenses because they could impact whether discipline is appropriate.
And then that would generate another proposed memorandum of decision to come back to us. And so we
Correct.
would have to do this again.
Not necessarily. It depends how the hearing officer ruled on the special
Okay.
defenses.
And it has to go back to the same hearing officer?
Correct.
Mm.
So my recommendation would be to, as Sal had begun to so move, is a motion to modify the proposed decision to reflect that the department has sustained its burden of proof with respect to all allegations and remand to the hearing officer to consider and rule on the special defenses.
Sal, can you just confirm so moved?
So moved.
Thank you. Can I have a second on that?
This is Cindy. I'll second.
Okay, discussion, board members?
So I guess, is this remedy,
Nope. We're
okay.
voting, we are voting on the statement of charges and our findings, correct,
Got it.
Attorney Bannon?
Correct.
Remedy will be next.
Thank
But
you for the
I
clarification.
welcome any discussion. So I would just like to say that in the record, it is clear that the pre-licensure RN degree did not contain the required clinical hours. This is clear. There is no argument. The respondent stated that there was no clinical. Over 100 nurses in this state have had their licenses revoked for the same exact reason, because that makes a person unsafe to practice nursing. So I am in agreement with the motion. I'm not in agreement with it going back to the same hearing officer. And I'd like that on the record. It sounds like I don't have any choice. I would prefer there would be another hearing officer assigned. But I guess that's not an option, even though we are told we can do modifications. We can't do that. So I would just like to say that on the record. Any further discussion before we take a vote? Actually, I do have one other thing to say. I am very proud of the fact that in the state of Connecticut, we have a board that is so committed to ensuring safe patient care. So I would just like to say that. Thank you to the board, because this has been a lot of work. Are we now ready?
This is Lisa.
Yeah.
This is Lisa. I just want very quickly, not belabor the point, but to say that the patients of Connecticut deserve to have nurses who are well qualified, and so much can be learned.
Your connection is
again?
so bad, Lisa. I don't think we can hear you. You're really breaking up. Anybody else hear Lisa?
No.
Try one more time.
I definitely have a bad connection today, but I just want to say that on behalf of the patients who deserve the proper care from their nurses, I think that our procedures and regulations are very well thought out. And I think too that it has to be acknowledged that as much as the nurses are studying books and lectures, it's their clinical time that is really, really important, because that's when the fine points of nursing come up for discussion and practice. And this is such an unfortunate situation in terms of the fraud that's being perpetrated by the people down in Florida who ran the schools. We're not faulting the nurses being for being taken by the programs down in Florida, but we still have to stand up for the protection of the patients in Connecticut. It's a hard move for us. We have a lot of compassion, a lot of empathy, but in the end, it's the safety of the Connecticut patients and people. So, thank you, Mary, and everybody else on the board, listeners, for speaking up on behalf of patients, because that's really what this comes down to.
Thank you, Lisa. Anyone else have anything to add before we take a vote? Okay, so we are voting on the motion on the floor. Sal Diaz,
Aye.
Lisa Freeman,
This is
Lisa,
Liz Van, Lisa, we couldn't hear you. Sorry, Mary.
Yes.
Susan Yan,
Aye.
Cindy Arpin,
Aye.
Camille Payne,
Abstain.
Diane Whitley,
Aye.
and I, Mary Dietman, vote aye. So we are approving that motion, and now we need to go to remedy.
And Mary, just for now, I think the remedy right now, actually, never mind. The remedy, actually, let me say this. So I think right now, my advice to the board is to discuss remedy. However, as I indicated, Attorney Menschel did raise 2 special defenses. So you're discussing a remedy in the event the hearing officer, finds that he did not establish any special defenses exist, what the appropriate remedy would be. Linda, oh, sorry, excuse me.
If I'm remembering correctly, I believe that the hearing officer did grant the department's motion to strike the special defense with respect to latches. Attorney Menschel, feel free to correct me if I'm wrong, and that the issue that was briefed and that there was the additional hearing date on was the special defense of promissory estoppel only.
Yeah, that's correct. The promissory estoppel was the one that we chose to continue to assert, and that the hearing officer has not had a chance to rule on because he ruled in Ms. George's favor.
Thank you, counsel. I appreciate the clarification. So kind of revising some of my statements that there is the special defense of promissory estoppel, which the hearing officer will consider. So in the event he denies that Attorney Menschel has established that special defense, the board can discuss discipline. And I want to just note as well that Attorney Baum, as well as all of the attorneys in the hearing office, are good lawyers. They are competent, they are committed, and they really dig in, so that they are committed to doing this work and arriving at the right conclusion. So I have the utmost confidence in every single hearing officer in my office.
Thank you, Attorney Bannon. So what I'm understanding is that we give a proposed remedy. Is that correct? A motion for a proposed remedy based on our findings.
I think that this is going to be more of
a recommendation.
A recommendation
versus a
at this
remedy.
point.
I mean, I think we're in really uncharted waters right now.
We are.
Because we are a board that has just considered this case, the statement of charges, and we have obviously a major disagreement with. I understand your defense of your hearing officers, but I think for us, or at least for myself, You know, being a committed nurse in this state, we have a problem with it. And we would like to, I think, have a recommendation on the record.
And I think that that's fair. I think what I'm going to advise the board to avoid is there is still a question open here, which is the special defensive promissory estoppel. So I'm going to recommend that the board not vote with respect to any discipline, because as I think we've said a few times, we can't put the cart before the horse, but I think it's fair. And I think that Attorney Baum has understanding of, you know, the board's consistency with respect to discipline under certain circumstances and for various types of proven conduct.
Okay, so please advise us on how to proceed.
Well, I think the board has discussed, you discussed it before you formally voted as to what a remedy would be appropriate. Mary, yourself had suggested revocation. You acknowledged that in these types of cases, the board has consistently revoked licenses. So I think that there is a record of the board's proposed discipline.
Okay. So we're done with this matter?
I think that that's sufficient, yes. And so
Okay,
again, just I just want to summarize.
Sure.
So this will be going back to Hearing Officer Baum with the directive that this proposed decision has been modified to reflect the department has sustained its burden of proof with respect to all allegations in the charges. However, there is still the outstanding issue of the special defensive promissory estoppel. So he will consider that, issue a ruling, and a new proposed decision will be presented to the board in due course. And of course, provided to the attorneys in advance of the board's consideration.
Okay, thank you.
Thank
you
you,
all.
Attorney Menschel, Attorney Bannon, and Attorney Fazina. I'd like to call a recess at this point of 15 minutes, and then we will resume with item agenda number 6. Is everyone in favor of that? Just nod yes or no.
Yes,
Okay.
I need to go to the bathroom.
Okay, so 15 minutes it is. Thanks, guys.